Hi everyone. Um, I'm just waiting for the live stream to start, and then we can the start the process. So we'll just wait for that. Okay, it started. Welcome to the Office of Tax Appeals. I want to thank everyone for attending today. My name is Josh Lambert, and I'm the lead panel member for this hearing. The panel will meet after the hearing and produce the written opinion as equal participants. Before we go on the record, I just want to discuss a couple of things. The Office of Tax Appeals is not a court, but an independent appeals body. The office is staffed by tax experts and is independent of the state's tax agencies. This hearing will be transcribed using Zoom. To ensure we have an accurate record, we ask that everyone state their name before they speak and that everyone speaks one at a time and that they do not speak over each other. Please mute your microphone if you're not speaking, and also please speak loudly and clearly. When needed, the panel will stop the hearing process and ask for clarification. After the hearing, the official hearing transcript will be available on the Office of Tax Appeals website. Were there any questions before we go on the record? No? Okay. We are now on the record in the Office of Tax Appeals oral hearing for the appeal of Jianzhong Sun and Bei Huang, case number 2308-14199. The date is November 20th, 2025, and the time is 1 p.m. My name is Josh Lambert, and I'm the lead panel member for this hearing, and my co-panelists today are Hearing Officer Kim Wilson and Administrative Law Judge Sarah Hosey. So, FTB, can you please introduce yourselves for the record by stating your names?
Good afternoon. This is Vivian Ho, along with my co-counsel Maria Brosterhouse for the Franchise Tax Board.
Thank you. And for appellants, can you please introduce yourselves for the record by stating your names?
My name is Bei Huang. I'm a parent.
Hi, thanks. Thanks for attending. And representing appellant?
Good afternoon. My name is An Yi Hui, and I'm the TAP representative for appellants.
Okay, thank you. Thank you all for attending. The issues in this hearing, in this appeal, are whether appellants have established a basis to abate the notice and demand penalties for 2018 and 2019, and whether appellants have established a basis to abate the collection cost recovery fee for 2018. FTB provides exhibits A through S, and appellants provided exhibits 1 through 8 because there was a recent submission that had 8 exhibits. And also, I noticed that in the appellant's brief, in your opening brief, you attached a claim for refund denial. And I'm not sure if that's included in your exhibits that you provided or in FTB's exhibits. So would it be possible to add your attachments to your appeal letter as Exhibit 9 so I can get the notice of action in as an exhibit this week?
Yeah, sure.
Okay. And FTB, did you have any objections to appellant's exhibits?
No objections.
And for appellants, did you have any objections to FTB's exhibits?
No.
No.
Okay. So that evidence is now on the record. So before we begin, Ms. Wang, you said that you wanted to testify as a witness, so I could swear you in now. Can you raise your right hand? And do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. So, Ms. Sui, this will be your opportunity to explain appellant's position, and you have 30 minutes, so you can proceed when you're ready.
Thank you, Your Honor. This case involved Ms. Huang and her husband, Mr. Sun. In 2021, the FTB issued notice asking them to file their 2018 and 2019 tax returns. At that time, the returns have not yet been filed because Ms. Huang's family was in crisis. Her mother was battling stage 4 lymphoma and required intensive daily care from her. Her father, in his 80s and recovering from knee replacement surgery, also relied on her for daily cares. Ms. Huang herself was dealing with significant mental and medical issues. Mr. Sun was working extraordinary hours as an essential worker during the pandemic. The team that he led helped bring forward the first FDA-authorized COVID-19 antigen test. His work directly impacted public health and helped save lives. Even with all this happening at the same time, Ms. Huang continues contacting the FTB again and again for extension, trying to stay compliant. She continued to do so throughout 2021 and into 2022. When their family situation finally stabilized enough for her to complete the paperwork, she filed the 2018 tax return in April 2022 and 2019 returns in November 2022. However, the FDB later informed them that the filings were still considered late and imposed penalties. To understand how this ultimately affects their tax filing, we look briefly at their background. Both appellants immigrated to U.S. in 1994. For nearly 30 years, have had excellent payment history, always withholding more than eventual tax liability, resulting in refunds. The 2018 and 2019 tax year were the only exception that have tax issues. These were the years when her health collapsed and her family responsibility becomes overwhelming. In 2019, Ms. Huang's mother was diagnosed with stage 4 lymphoma. Ms. Huang served as her mother's full-time caregiver and translator. According to Exhibit 1, she attended over 380 UCSD doctor's appointments between November 2019 and July 2022. These were only medical visits and did not include chemotherapy, CAR-T clinical trial, bone marrow transplant, repeated imaging, or lab testing. Each time she thought her mother had stabilized and could turn her attention into Texas, her mother relapsed, forcing her to postpone again. Ms. Huang's mother oncologist letter in Exhibit 6 confirms her mother's September 2021 bone marrow transplant, after which the doctor required at least 6 months of full-time intensive caregiving, exactly overlapping the FTB demand deadlines. During that time, Ms. Huang herself suffered from major depression, anxiety, panic attack, and several heart and endocrine conditions documented in Exhibit 4, Kaiser Physician Letter, and Exhibit 5, UCSD Psychiatric Note. In Exhibit 8, her UCSD Psychiatric Note records show a GAD-7 anxiety scores of 14 with functioning marked as very difficult, confirming her mental incapacities. At the same time, Mr. Sun was an essential employee at Quidel's Corporation, shown in Exhibit 3. He led the team that developed the first FDA-authorized rapid COVID-19 antigen test in May 2020. His position requires long hours of work to help protect public health during the pandemic. In Exhibit 7, you can see his W-2 income has increased significantly, reflecting the work long hours during pandemic. Despite his demanding schedule, Mr. Sun was responsible and attentive with their tax obligations. He regularly followed up with Ms. Huang, asking about the filing and whether she needed help. Each time she showed him her note on the FDB notice, the same handwritten note that now showing appear in Exhibit 2, and explained that she had already contacted FDB and received extensions because she had handled the tax filings for decades and was active contact with FTB. He had no reason to believe there was a problem. When she told him she had taken care of it, he trusted her reasonably, giving her consistent record of compliance and the confirmation he saw in Exhibit 2. Based on that, he reasonably believed everything was under control. To further understand more about their situations, I would now like to call Ms. Huang to testify. Ms. Huang, I know these years have been very difficult. Can you tell us more about your health during this period? How were your depressions and anxiety affecting your daily lives?
It was very serious. I often didn't want to wake up and hardly fell asleep every night. I couldn't stop worrying about everything. Caregiving for my parents, my kids, the housework. I even had suicidal thoughts and once took action because I felt so hopeless. It was hard to function or focus on anything, especially tax paperwork.
I can feel you are very overwhelmed. Um, what were the reason? Can you tell us more about your caregiving responsibilities? Like how many hours a day were you spending caring for your parents and managing your household?
Almost the entire day. The only time I wasn't working was when I was asleep. From the moment I opened my eyes each morning, I had to start fulfilling caregiver responsibilities. My mom has stage 4 lymphoma, and my father is in his 80s and recovering from knee replacement surgery. I drove them to their own appointments, translated, managed medicines, cooked, cleaned, and often stayed up late to monitor my mom. Imagine how much work it is to take care of one elderly sick person. I have two elderly sick patients to take care of. So there was hardly any time for myself.
If your parents' illness caused so much delay, why didn't you delegate their care to someone else?
Because no one else could communicate with their doctors. My parents speak Shanghai dialect, and the hospital interpreters only spoke Mandarin. So I was the only person who could translate. I couldn't leave them alone for a single appointment.
And if you were so ill and busy with caregiving responsibility, why didn't you hire a CPA for tax filing?
I've always filed our taxes myself, and I'm very private about our finances. During the pandemic, I didn't feel comfortable meeting new people or sharing personal data online. Most CPA offices were closed, not taking new clients, or only allowed contactless drop-offs, which made it hard to communicate. Since I've been doing our taxes accurately for decades, and we will always do refunds, I planned to handle it myself. But every time I was ready, my mother's health wasn't again, and I had to focus on her care instead.
What about your daughters? Why didn't your daughters help with the caregiving or the taxes?
My daughters really wanted to help, but they couldn't. They're still in school at that time during the pandemic, they are also facing their own challenges and trying to adapt to everything that was happening around them, such as constant class schedule changes, homework workload, exams, stress. Even if they tried, they could only help in very small ways. They couldn't take over hospital visits or make medical decisions for my parents. And when it comes to taxes, they have no experience with tax preparation at all. So I didn't want to put that burden on them when they were already struggling with school and adapting to the pandemic.
What about your husband? Why didn't your husband help?
During COVID, he was leading a team at Cordell that worked long hours to produce the first FDA-approved rapid antigen test. He worked day and night. Even then, he still asked about our taxes, and I told him I had contacted FTB and received extensions, so he didn't need to worry, and he could focus on protecting the public health. He trusted me, and based on FTB own reassurances, I believe everything was under control.
Speaking of the FDB, you made 285 calls to the FDB. If you could call that often, why couldn't you use that time to file the tax return?
Making a call would take too much time. I could do it while waiting in the hospital or sitting in the car, but the a tax return took hours of concentration and organizing paperwork. At that time, I was physically weak, often dizzy from low potassium and a medicine side effect, and mentally exhausted from depression and panic attacks. I simply could focus long enough to complete the forms, even though I wanted to. Calling was my way to stay responsible and let FTB know I hadn't forgotten my duty.
Why should we believe that your call really happened? Because 285 calls to FTB seems a lot.
Uh, because I have 3 years of phone logs from Verizon, and I had some handwritten call notes written on the FTB notice in Exhibit 2. Those handwritten notes are the verbal extension I had got from FTB.
When you received those notices, why didn't you send a written response back to FTB? Can you explain why?
FDB representatives told me phone calls were enough and that they will make detailed notes in the system. No one said I have to write back. I thought I was already responding properly.
You mentioned that you received verbal deferral. Why did you rely on verbal deferral from FDB instead of the written ones?
Because I spoke directly with FTB agents and assumed their statements are official. They told me as long as we will do a refund, there will be no penalties. I trust that.
I believe an ordinary person would do the same. Miss Huang, did you ever stop trying to file?
No, never. I kept my tax papers by my bed and worked on them whenever I could. But my mother's cancer or my own illness always interrupted. It wasn't negligent. It was crisis after crisis.
Speaking of the crisis, the 2018 return was actually due before the pandemic. Why was it still late?
I actually filed an extension for 2018, But even before my mother's diagnosis, she was showing symptoms, and my father required daily care after his knee replacement surgery. He needed ongoing physical therapy and a constant assistance to prevent falls. At the same time, I had my own health crisis, an ER visit for dangerous low potassium, and my husband had to travel to China to care for his sick mom. So even before COVID, life was already chaotic. Then when the pandemic started, everything fell apart.
Thank you, Ms. Huang. I have no further questions. Your Honor, I will now turn to legal argument. The question here is whether the 2018 and 2019 notice and demands penalties and the 2018 collection cost recovering fee should apply under these circumstances. Under California law RNTC section 19133, a demand penalty may be abated if the taxpayer lacked willful neglect and had reasonable cause. Our argument has four bases supporting reasonable cause. 1. Ms. Huang had mental and physical incapacity that prevented her from managing ordinary affairs, satisfying the Boucher standard. Second, Ms. Huang acted as an ordinary prudent person by actively communicating with FTB and relying in good faith on their reassurance, satisfying the TONS standard. Third, Ms. Huang's overwhelming caregiving responsibility for two elderly sick parents, including at least 6 months of intensive care after transplant surgery, also independently established reasonable cause. And fourth, Mr. Sun, as an essential worker under extraordinary demands, acted reasonably and prudently by actively following up and relying on his spouse's documented communications with FTB. I will now address each of these four grounds in turn. Together, they reflect a complete picture of two taxpayers who act responsibly and in good faith, but were overwhelmed by circumstances far beyond their control. Number 1. Under the appeal of Boucher, case number 2021-OTA-284P, mental or physical incapacity constitute reasonable cause when the taxpayer is unable to manage other affairs with ordinary care. The record shows that from late 2019 through 2022, she was simply not capable of managing tasks that requires long hours of concentration. In Exhibit 4, her Kaiser physician documents major depression, panic attack, sleep problems, low potassium, and cardiology problems. And the documents state that these conditions impair her ability to complete tasks such as filing tax returns. Exhibit 5, her UCSD psychiatric note further shows poor concentrations, extreme fatigue, and losing track of time, all incompatible with the focus, organized work required for tax filing. In Exhibit 8, her GAD-7 assessment reflects a score of 14, which is clinically classified as moderately severe anxiety, with daily functioning marked as very difficult. Taken together, these exhibits demonstrate incapacity throughout the entire filing period, fully satisfying Boucher. Number 2, under the appeal of Howard and Mary Towns, case number 79-SBE-027, the standards for reasonable cause is whether an ordinary prudent business person under similar circumstances would have acted the same way. Miss Huang acted the same prudent expected of an ordinary intelligent business person under the Tong standard. When she realized she could not meet the original deadline because of the medical and caregiving crisis, she turned to the FTB for guidance. Exhibit 2, which contains both FTB written deferral letters and Ms. Huang's handwritten note on the demand notice, shows that she is in active contact with FTB. Based on the Verizon call logs, approximately 285 calls were made to FTB explaining her situation. The FTB owns agents told her that as long as her return shows refund, penalty would not apply. Any prudent person, when speaking directly with the representative of the tax authority, would rely on that guidance. Ms. Huang conduct was entirely reasonable and fully consistent with the standards in towns. Number 3, even apart from illness and FTB misguidance, Ms. Huang's caregiving responsibility independently established reasonable costs. Exhibit 1, the UCSD appointment log shows over 380 medical visits for her mother between late 2019 and July 2022, evidence of daily ongoing medical crisis. They did not include chemotherapy, clinical trial, bone marrow transplant, repeated imaging, or lab testing. Then Exhibit 6, the UCSD oncologist letter confirmed that after the bone marrow transplant in September 2021, Ms. Huang was required to provide at least 6 months of full-time intensive caregiving. Together, this record shows she was responsible for 2 elderly parents while also dealing with her own medical decline. Under these circumstances, it should have been unreasonable to expect timely tax filing. The caregiving burden alone established reasonable costs. Number 4, Mr. Sun also had reasonable costs. Exhibit 3 confirms that he was an essential worker at Quidel Corporation and part of the team that developed first FDA-authorized rapid COVID-19 antigen test, a critical public health tool during the pandemic. The W-2 in Exhibit 7 demonstrate rising income during pandemic, which was because of the rising workload. Even though the workload was intense, he consistently following up with Ms. Huang regarding the tax return. And when she told him, backed by the document FTB deferral in Exhibit 2, that she had spoken with the FTB and extensions had been granted, he reasonably relied on those assurances, giving her decades of handling family filings and the visible documented communications that she had with FTB. He had no reason to believe anything was amiss. Under Tong's, a prudent spouse in his circumstances would have acted exactly as he did. I would also like to refer Tabby versus Commissioner TC Memo 1995-463. In this case, the tax court held that a couple have reasonable cause for late filing even though the husband was healthy, working, and fully capable of running several real estate business. What mattered was their child underwent major heart surgery, was hospitalized for months, and later passed away. The parents spent nearly all of their times at the hospital, and the court found that these caregiving responsibility and emotional strain were sufficient to constitute reasonable cause. That rules apply strongly here. Mr. Sun, like the husband in Tabby, was not physically incapacitated. He was working and working under extraordinary pressure as an essential employee supporting COVID-19 test development, but he was also dealing with family crisis involving life or death medical care, repeated hospitalizations, and the emotional weight of supporting his wife through her own health decline. Under Tabby, a taxpayer does not need to be ill to have reasonable costs. Overwhelming family medical crises alone are enough. The same truth here. Lastly, the 2018 collection cost recovery fee cannot legally stand because there was no balance due for that year. As shown in FTB Exhibit F, the franchise tax bar own calculation shows 2018 tax liability of 3,176, while the W2 withholding was 4,629, more than enough to cover fully satisfies the tax. Because 2018 have no collectible amounts owed, the fee was incorrectly triggered. Mhm. Yeah, that's all.
Okay. Thank you, Ms. Sui and Ms. Wang, for your testimony. I'm sorry to hear about your circumstances. I will turn to FTB to ask if they have any questions for the witness.
Uh, yes, thank you. I have one question for the witness. Ms. Huang, thank you for being here today. During 2021, did you contact any CPA for assistance with filing your tax return?
I'm sorry, can you repeat the question one more time?
Yes. During 2021 or earlier, did you contact a CPA for assistance with filing your tax return?
No.
Did you attempt to contact any tax office to see if they offer in-person service?
Actually, I actually try to thought that, but just it's so hard for me to like find the new or right the firm to because everything's so hard during the pandemic, and also because I'm the mental ill person, that make me very nervous related our family like finances.
Thank you for your response. No further questions.
Thank you.
Thank you. Hearing Officer Wilson, do you have any questions?
I do not have any questions. Thank you.
Thanks. And Judge Hosey, do you have any questions?
This is Judge Hosey. No questions, but I appreciate your testimony, Mrs. Wang. We appreciate you being here and sharing with us.
Thank you so much.
This is Josh Lambert, and Ms. Wang, I had a question. I was wondering, there was also a request for tax return that FTB sent for 2017, which is not a year at issue. And was the reasons for not responding to that one the same as the reasons for the years that we're looking at on this appeal?
Actually, that one I responding, it's the delayed, it's for my, first they said they didn't receive my the tax return, and I showed them I mailed with the together at the IRS with this, but that they said that they never received it, so I have to redo everything again. So then it's caused the delay. Another issue is for decades, because we have 5 dependents, so for the dependent, the form only 4 column. Every time I put my mom and dad handwrite there and with their name and social security number. For some reason, for that particular year, the system scan didn't catch that. So actually my 2017 is almost 4,000 refund. And they said, turn out we owe them $97. They want to collect that. So I contact them and show them we have a 5 depend, not 3. And they said I have to submit all the proof. I did everything according, but just because all those the pandemic make this very, very long. Like they finally, I think is 2022, I think like February around that time. Finally, I got supervisor and the supervisor narrowed down they said have to clean that up. Cannot take that long. And I already submit everything. Original, when I submit, I attach everything. And now they want my mom and dad, their social security card, all those. I just do everything what they ask, but just take forever. Like they solve this until I think it should be February like 2022. They turn this as the 4,000, almost 4,000 refund. Instead, they try to collect the said I have $97 outstanding.
Okay, thank you, Ms. Wang, and appreciate your testimony. And thank you, Ms. Wee. Now we can move to FTB's presentation for 15 minutes. So Ms. Ho, you could proceed whenever you're ready.
Thank you. Good afternoon. My name is Vivian Ho. I, along with my co-counsel, Maria Brosterhouse, represent respondent, the Franchise Tax Board. The issues presented before you today are whether appellants establish reasonable cause for abatement of the demand penalty for tax year 2018 and 2019, and whether appellants have established grounds for abatement of the collection cost fee for tax year 2019. FDB correctly imposed the demand penalty for tax year 2018 and 2019. The demand penalty is imposed when a taxpayer fails to timely respond to FDB's demand for tax return and has also previously failed to respond to a request or a demand for tax return that resulted in a proposed tax assessment in one of the preceding 4 tax years. For tax year 2018, appellant wife met the requirements for imposition of the demand penalty. For tax year 2019, appellant husband met the requirements for imposition of the demand penalty. As appellants filed a joint tax return for both years, appellants are jointly and severally liable under California law for the tax due as well as any penalties associated with the tax. As such, appellants are jointly liable for the demand penalty imposed for tax year 2018 and 2019. Appellants assert that they were granted multiple extensions for responding to the demand notice. While that is correct, FTB records do not indicate that appellants were continuously granted extensions until the day they filed their tax return for both tax years in April of 2022. For tax year 2018, while appellants contacted respondent regarding the FDB notices they received, appellants were not granted a deferral before the issuance of the proposed assessment. For tax year 2019, the record shows FDB allowed additional time for appellant husband to respond to the demand notice, but appellants did not timely respond within the extended time frame. Appellants were also granted multiple collection holds on their accounts when they contacted FDB by telephone, as there was an assessment against appellants based on their non-filing. As the demand penalties were correctly imposed, the burden of proof is on appellants to establish reasonable cause. None of the reasons appellants provided are basis for reasonable cause. Firstly, FDB would like to address appeal of voucher, which appellant cited. In that opinion, OTA sustained FDB's determination on penalty, stating that the law sets a difficult standard to establish reasonable cause based on mental illness. In that case, OTA found the taxpayer to have failed to establish reasonable cause due to illness, due to her ability to handle non-tax matters. Respondent will also like to note that appellants claim that FDB agents stated that no penalty will be due to appellants is incorrect. As shown in respondent's exhibit P and Q, in response to appellant's statement to FDB agents that they were advised by their CPA that no penalties will be imposed, FDB agents corrected appellants and notified them that penalties may still be imposed even if they do not owe a tax liability. And on to the standard for reasonable cause, appellants must establish that the failure to timely respond to FDB's demand notice occurred despite the exercise of ordinary business care and prudence. Appellants assert that appellant husband was overwhelmed with work responsibilities due to being employed in an essential medical field. However, as held in the presidential opinion of appeal of Head and Feliciano, selective inability to perform tax obligations while participating in regular business activities does not establish reasonable cause. Appellant husband chose to prioritize his employment over his tax obligations and must bear the consequence of that choice. While respondent is sympathetic to the difficulties appellants face, appellant husband was not prevented from filing a tax return and should have responded to the demand notices and to the couple to file their joint tax return if a appellant wife was unable to.
Ms. Ho,
Yes.
can you make sure that you speak closer to your microphone? Because when you back up, it kind of is hard to hear you.
Oh, I apologize.
That's
Should
better.
I repeat any part of my presentation?
Maybe the last part of it, the last couple sentences.
Okay, thank you. Appellants assert appellant husband was overwhelmed with work responsibilities due to being employed in an essential medical field. However, as held in the presidential opinion of appeal of Head and Feliciano, selective inability to perform tax obligations while participating in regular business activities does not establish reasonable cause. Appellant husband chose to prioritize his employment over his tax obligations and must bear the consequence of that choice. While respondent is sympathetic to the difficulties appellants face, appellant husband was not prevented from filing a tax return and should have responded to the demand notice to file the couple's joint tax return if appellant wife was unable to. A taxpayer exercising due care and diligence when receiving a demand notice would notify their spouse to file their joint tax return or otherwise obtain tax professional assistance. It was not reasonable for appellant husband to rely on appellant wife's unsubstantiated statement that their tax obligations were taken care of without any confirmation that these obligations were fulfilled. And regarding appellant wife's obligation to file her tax return, it is respondent's position that she should have obtained assistance of a tax professional when she received the demand notices or within the extension period for assistance to filing the returns if she was unable to. In regards to the collection cost fee, there is no reasonable cause defense to the imposition of the fee. The OTA's inquiry is limited to determining whether FDB complied with the statutory notice for imposing the fee. FDB provided satisfactory notice to appellants that the collection cost fee will be imposed. As such, there is no basis for abatement. FDB respectfully requests OTA sustain FDB's determination and deny appellant's claim for refund. Thank you. I can take any questions the panel may have.
Thank you, Ms. Ho. Hearing Officer Wilson, do you have any questions?
I do not have any questions. Thank you.
Thanks. And Judge Hosey, do you have any questions?
This is Judge Hosey. No questions, but thank you for your presentation.
This is Judge Lambert, and I just had one question. Ms. Ho, could you just maybe respond to what appellants were stating, that there was no tax due on the returns that they filed, so they shouldn't owe a penalty?
Yes, this is regarding appellant's argument that they received advice from FTB agents regarding the penalty.
Yeah, and that there was no tax dues, so they shouldn't have a penalty, or they reported no tax due?
Yes, thank you for clarifying. Regarding the demand notice, a penalty is imposed for failure to reply to the notice and not based on whether the taxpayers owe a liability. As such, based on appellant's failure to respond timely to the demand notice, the penalties were correctly imposed, and FDB records show that there is no indication of any advice to appellant regarding that there will be no penalties imposed. Instead, what FDB agents notified appellant was that there are potential for penalties. This is in response to appellant's statement that their tax preparer advised them that no penalties will be due when they do not owe a liability.
Okay, thanks. So,
I'm sorry, I think I can clarify just a little bit.
Okay.
I think the important distinction here is that the late filing penalty is based on the amount of tax owed on the due date, whereas the demand penalty is calculated differently and it's based on the amount of tax itself, not what was owed on the due date. And so I think a lot of people conflate the two. Just to clarify, thank you.
Okay, thank you, Ms. Prosterhouse, for clarifying. Thank you. Okay, so now we can move on to appellant's closing remarks. So, Ms. Wee, you can make your closing remarks for 5 minutes.
I'm sorry, I have something to clarify. For the husband job is less for personal business pursuant, but it's more for finding a COVID testing kit or like a solution for the benefit of the whole world. His job is more like a firefighter sent away to combat fires or a soldier sent to combat zone. Thus, it should be like judged differently. I just wanted to clarify that one. Now I can move to the closing. Okay. Your Honor, members of the panels, this case is not about neglect. It's about two taxpayers who did their best under extraordinary hardship. For nearly 3 decades, Mr. Sun and Ms. Huang had excellent payment history. Their returns constantly result in refunds. The delays in 2018 and 2019 tax filing were caused by a medical crisis and overwhelming caregiving responsibility, not disregard. Ms. Huang was in many ways like a firefighter with a fever, still running into burning buildings while being sick herself. She juggles hospital visits, translations, and day-to-day caregiving while battling depression, anxiety, panic attack, and repeated ER-level medical issues. Imagine how much work it is to take care of one elderly sick person. She has two. The UCSD doctor's letter shows she was required to provide at least 6 months of intensive care after her mother's September 2021 bone marrow transplant. At the same time, Mr. Sun was serving the public as an essential worker, helping bring forward the first FDA-authorized rapid COVID-19 antigen test. Even with that workload, he remained responsible with their tax obligation. He constantly checked with his wife about the taxes, and when she told him she had spoken with the FTB and obtained extensions, his reliance was reasonable under the TON standard. Despite everything she was facing, Ms. Huang never stopped communicating with FTB. She made 285 calls, receiving written notice and verbal deferrals, and acting in good faith. When she finally filed the tax return, she still believes she is within the time allowed. Under RNTC Section 19133, Taunt, Belcher, and Tabby, the records demonstrate reasonable cause and absence of willful neglect. These penalties exist to defer non-response, not to punish those people who keep communicating through hardship. Ms. Huang did exactly what FTB encouraged. She reached out, she explained her situation, and she followed the guidance. For all these reasons, we respectfully request that this panel obey the 2018 and 2019 notice and demands penalties and 2018 collection cost recovery fee in full. Thank you, Your Honor.
Thank you, Ms. Wee. So if there's nothing further, I'm going to conclude the hearing. I want to thank both parties for appearing today and Ms. Wong for giving her testimony. And we will issue a written opinion within 100 days. So the record is now closed.